Hello and welcome to Personal Injury Today, where we talk about the top topics to help attorneys better understand their clients' cases and come to a fair settlement. In today's episode, we're going to dive into understanding why we get low settlement offers and how to better arm yourself in your client's case to negate those offers. Today we have Dr. Brad Poppie with us to help fill us in on some secrets that you need to know as you move forward with your client's case. On today's show, we're going to start to talk about why insurance adjusters give lowball offers on some of your clients' cases and what we can really do about that. Dr. Brad Poppie is the founder of Injury Reporting Consultants, helping attorneys just like you resolve your clients' cases through evidence-based medical analysis and reporting. We've got Dr. Brad Poppie on today to help us shed some light on what attorneys can do to add the correct amount of value so insurance adjusters make a more reasonable upfront settlement offer for your client's case. Welcome, Dr. Brad.
Thank you so much.
Why are insurance adjusters so trained to lowball offers from the gate?
Well, they're trained to do that. That is their strategy. So you have to look at it from the defense point of view or the insurance company point of view. It's their job to do the best for their client. And what that means is, get as low of a settlement, that offer that they can get. So the less money that comes out of the insurance company's pockets, the better, right? So that's their tactic, that's their side, which is understandable.
They're protecting the insurance company.
Exactly. Where the plaintiff side, they want more money for their client. So it's a give and take and a negotiation at the end of the day. So one of the reasons why insurance adjusters offer a very lowball settlement right out of the gate, it's a few different things actually. One of them is there may not be clear liability or causation. It might be, well, who hit who? We're not really sure, and maybe our client, the defendant's partly to blame, and maybe the plaintiff's partly to blame. Maybe there was no, police officer on the scene to fill out a report, things like that. It's kind of sketchy. So that might be one reason. Number two, maybe the plaintiff, the client, had a pre-existing condition. So maybe after the car accident, they are now having low back pain. And, well, gosh, for the last 5 years, they've been seeing a chiropractor for treatment for low back pain. Well, which caused which? Did the car accident cause the low back pain, or was it their previous skiing accident 5 years ago, right? And also, sometimes they look at the treatment that the client has had and they call it excessive. Maybe the insurance company has had a expert evaluation or an independent medical examination done on the client, and they say that all this treatment has been, it wasn't needed, the patient should have got better within X treatments as opposed to Y treatments that they had. And so the insurance company says, hey, this is why we have a low settlement offer, because all this treatment that your client went through wasn't needed.
So, and some of these things that you're talking about, they're pretty common. It's fairly common for someone to have other ailments or pre-existing conditions. I'm sure some of the attorneys watching today are like, yes, we experience this all of the time. So understanding that helps tremendously. And if you're finding value in this video and some of the other videos and episodes that you've seen through Personal Injury Today, please share this video with other attorneys, share it with your clients, and then also subscribe to this channel and hit the bell notification so that you can be updated as we produce additional content and add more videos on this channel. So it sounds like insurance adjusters just really don't truly understand the extent of the injuries that have taken place. How do we combat that?
It's kind of a twofold question. So again, we talked about that's kind of their job. That's what they're supposed to do. So then it leaves the plaintiff side, the plaintiff attorney, to say, hey, how do we show the true objective value? How do we give the insurance company more data so they understand the true effect of the client's injuries and how it affects their life? Okay, so here's an example. Let's say that on the plaintiff side, they're claiming lost wages because their client cannot go back to work, or maybe it's that particular job, maybe it's they go back to light duty, they can't anyway sustain the same amount of hours and the pay that they had once gotten prior to the accident. So the client says, I can't go to work and do this job anymore. So they claim X amount of damages. And the insurance company side, the defense side, they're like, well, hey, you know, we have an expert evaluator, an independent medical examination doctor that's going to take a look at this client and see what they think. And they deserve that right. They can do that. So their doctor will do an exam, and they may come back and say, your client is fine. They don't have any impairments or disabilities. They should be able to perform their job duties no problem. Pain-free, everything should be fine. Okay, well, now we've got, okay, well, who's right, who's wrong? That's when, again, the attorney needs to reach out and bring out the heavy artillery.
Right.
Okay, bring out the heavy guns.
guns.
Yeah, you know, the true objective measures. You know, how do we do that? So again, in that particular example, it's a functional capacity evaluation. Functional capacity evaluation is the gold standard or industry standard on how we document someone's impairments and disabilities and how they affect their life. You know, more specifically, you know, their ability to perform work-related activities. Okay, so it's literally a 4-hour exam, and at the end of that exam, the functional capacity evaluator really knows what that patient can or can't do. Okay, so then they will take that FCE or functional capacity evaluation and then give it on to a vocational rehab consultant, and that person will do a earnings capacity loss report and take the impairments and disabilities from the FCE and then put dollar signs to it and really show, you know, based on this FCE, they cannot do ABC, XYZ job duties. And now here's the actual dollar signs extrapolated through life expectancy that is the true damages. So that's an example, okay? Another one might be, again, we talked about opposing counsel or the defense side may have an independent medical examiner or an expert evaluator look at the client and determine, hey, this client does not need any more treatment. They may think that their treatment should have been usual, reasonable, and customary months ago, and everything else has been not needed. So the insurance company says, well, we don't want to pay for that, which is understandable in their eyes. That's where, again, the plaintiff attorney needs to reach out to the heavy guns and say, how do we objectify this? How do we help the insurance company understand? When both parties understand, things get solved. And in this sector, it means let's get it solved outside of trial. Let's get it done in mediation. So in that instance, the plaintiff side needs to hire on a life care planner. Life care planner is going to be the person to be making the phone calls and collaborating with all of the treating providers that treated that patient, whether it's physical therapy, chiropractic, orthopedics, cognitive rehab, whatever, okay? And talking to them about what their plan of care is and why they need future treatment for X years, okay? And then the life care planner then does a huge report, almost a thesis on that patient, and then puts costs to those future care recommendations. And so when a certified life care planner does those reports, the insurance company understands, okay, this is a certified life care planner, this is a legitimate credential, and they start to take it more serious.
That's perfect. So we've said in this case, attorneys need to call out and bring in the big guns. I'm assuming you are the big guns.
I'm a big gun, yes. Yes.
One of big guns.
Yes.
So if I'm assuming that attorneys watching understand how to go about getting an FCE, or you know, what is that next step? Let's say if they don't know where to turn or how to get that FCE.
Yeah, absolutely. It's just, you know, visit us at, you know, injuryreportingconsultants.com. or shoot me an email, brad@injuryreportingconsultants.com. Either way, just reach out or make a call. Call us. We have our number on our website. Just give us a buzz, and I'll talk about the case. Done.
That's perfect.
It's pretty easy.
Awesome. Thank you so much for joining us and for watching. Again, like, share, and subscribe to this channel. And we will see you next time. As Brad said, please reach out if you have any questions at all about your client's case, and we'll talk to you soon.